Great, Chris, and thank you for the introduction. This is Robert, and we have Adrian here with us. Say hello, Adrian.
Hello, everyone.
Well, together, Adrian and I are going to have a conversation about the legal issues that are involved in the preparation of reserve studies. Based on the questions we receive on an ongoing basis, we felt it was appropriate to have this session in order to bring some clarity to this topic, to have us join together and provide some insights for you. But we know you've come with some expectations, and we want to make sure that this time is valuable for you. So on your screen, you'll see a dialog box. If you've come with a question, or if at any time a question comes to mind, please type it in the dialog box, which Chris will be monitoring. We'll try to answer as many as we can in the time available after we've prepared our finished content. Now, in addition, there's also a hands raised icon that allows you to respond to a question we might ask. So let's start off with some audience participation. Everyone grab your mouse and click that hands raised icon on your control panel to let us know you're ready to start the program. So click that hands raised icon. Oh, very good. Adrian, we have a sharp crowd today.
No good.
One more
Those
minute.
must be the ones who read. Those are the ones that read my newsletter.
Okay. Everyone, I'm going to now click to put your hands down. Thank you all. And it's time to start our session today. So first, let me ask Adrian, why are reserve studies done and how do they fit into a board's responsibility?
Well, it mostly deals with the common interest development industry. Reserves turned out to be a critical element because homeowner associations, consist of a separate interest and then common areas. The separate interest, for example, in condominiums is the airspace that they live in. It's the condominium. And then it's surrounded by a structure. That structure that's the common areas for that building, for that condominium. And associations are created for virtually the sole purpose of maintaining those structures. Because they're owned in common, somebody has to maintain them. And that's why the association is created, and then you have a board of directors elected by the membership. They set a budget, and you've got then two elements of that budget. You have the ongoing operational expenses that, like mowing the lawns, changing the light bulbs, those kinds of things that are just the regular ongoing expense to running the association. Then you have the larger elements that are expensive and are not replaced on an annual basis. Instead, it's a periodic basis that might be 10 years out, 20 years out. So a roof that might be replaced 20 years from now, that needs to be paid for at some point. That's what the reserves are for. They have to set aside a reserve fund. They need to save up the money for that and establish a funding plan that goes with that, and that's where the studies come in, that you need a study in order to tell you, it's the planning tool of how much money you need to save and when you're going to need to replace that roof. And failure to do that can lead to potential liability for the association.
Well, let me follow up. You say the reserve study needs to be done for that fundamental way to plan ahead for something far distant in the future and to be ready, but what if the association doesn't set aside any funds?
Okay, well, there are basically two different ways of looking at that. One is depending on the laws in a particular state. If there's a statutory requirement that an association actually have money set aside a reserve fund and have monies in those funds and have them at a certain percent level funding, then the association will be in violation of statute. So that carries its own liability in violation of the statute. But most states really don't have a requirement along those lines. They have mostly a requirement that they prepare a study and that they disclose that to the membership. Even so, the liability that they face is just through the general laws. People don't like getting large special assessments. In fact, one of the cases I was recently involved in involved an association that was 19% funded. And what happened was the association was approximately 30 years old. The plumbing started to fail in a large, as this slide shows, here we see the pinhole leaks showing. What had happened was the developer had installed a defective thin-walled copper lines throughout the association. And they started failing, and they started failing very rapidly. And the association was faced with having to replace all of that, and the board was able to go out and establish what the cost would be, and it was going to require a $20,000 per unit special assessment. One of the owners in the association happened to be a lawyer and turned around and immediately sued the association over that, claiming that the association, the board of directors, had been negligent because they had not set aside monies to replace those. And as this slide shows that you have now, people don't like it when water suddenly starts pouring into their units. And when you have large plumbing failures, this is what's going to happen. So whether it be a roof, windows, plumbing, in this case it was the plumbing, that resulted in the litigation. Now, the good news is that the association, after years of litigation, eventually prevailed. I testified in that case and was able to convince the judge of two things. I was able to show that the board had a reserve study in place, it had a funding plan in place, that it was following that funding plan, and it was not the plan that was the problem. It was this undetected construction defect that suddenly just started manifesting itself and creating all this damage. And I was able to show that but for this construction defect, they would have been fine with their funding plan. They were low, but they had a plan in place to build up to the proper levels and would have had the money when they needed it to make the replacements through normal wear and tear. So that, had it been different, had it been failures because of deferred maintenance, then the outcome of that litigation may have been far different. So that's the potential liability that associations face. And in, I don't know about other states, but in California there's case law that states that failure to adequately fund for reserves is a breach of the board's fiduciary duties. And so the question then is, adequately fund, how much is adequate? Yeah, and that's probably something that you can address, Robert, on funding adequacy.
Adrian, that's a nice segue. That's actually not a clear right or wrong answer. It's more like choosing an insurance deductible risk, because the association gets to choose its exposure to the risk of anything inappropriate or unfortunate that happens when their reserves aren't adequate. You can see the chart on the screen. An association's risk of a special assessment is measured by their percent funded. The lower their percent funded, the higher you get on the page here, the higher their risk of a special assessment. No surprise. If they strengthen their reserves, and you can see lower on the page, their risk of a special assessment goes down. So it's a risk management decision the board makes. That's why so many associations choose to fully fund their reserves, trying to have a target of being 100% funded, or at least keeping their reserves above the 70% level to minimize their risk of running out of money for a necessary project. Now, let me ask everyone here, let's do that same hands raised. By hands raised, do you understand that there's a direct relationship between the percent funded showing in your reserve study and your risk of special assessment? Hands raised if you can see the relationship between your reserves percent funded, which shows the strength of your reserve fund, and your risk of a special assessment. Great. Indeed, we have a lot of people on board with us. Okay, I'm going to put hands down.
Okay, then looking at this chart and setting this, looking at these percent fundings, are there other things that you look at, other standards that you use for when it's time to replace elements or components?
Adrian, that's a good question. The question of when is important because you don't want to have to call for a special assessment if you don't truly need to. So when we're thinking about the subject of when to replace something, we realize that every component goes from new to failure. There's different types of failures and different definitions of failures. So we've done an entire webinar called What Can You Ignore in Your Reserve Study? And I'll take just a moment to pop out and go to that. Going to our website, reservestudy.com, click on Learning Center, click on Webinars, and you'll see a webinar we did a month or two ago called What Can You Ignore in Your Reserve Study, right there. And that's a nice little overview of what drives some of your expenditures. And let me also point out there's also this Reserve Studies 102 here, the financial analysis, and that's a good place to get a clear explanation of the National Reserve Studies Standards definition of percent funded. Let me get us back to the webinar here and very briefly summarize how we see the failure of different associations. There's different categories that we put them into, 5 different categories. First off, there's inconsequential category. That means we kind of don't care, we just wait for it to fail. A good example for an inconsequential component would be like this picture of a water heater for a pool bathroom building. It's really not a big deal for the water heater to fail. It's pretty much outdoors, and the worst that happens is someday you find out that, gee, there's no hot water in the bathroom, so you replace it. It's kind of no big deal. That's an example of inconsequential. The second category would be the re-evaluate, something that you look at, you think, and you ponder, and if you can wait another year without a bad consequence, then perhaps you wait another year. Like obviously you see the rusting on this ironwork. Obviously the board could have painted this last year, but they chose to wait a year. It's somewhat inconsequential. It's a cosmetic issue, not a functional safety issue, something like that. Now, the third category is obsolescence. If it is not an issue of failing to serve its intended duty, but it's just an aesthetic issue. And let me show this sign here. It's a sign that I've blocked out the actual name of the resort, but it's a golf ranch in Arkansas, supposedly Arkansas's #1 resort golf club. And I get a kick out of the chipping of the sign and the typos in the sign itself. It really doesn't convey to me Arkansas's #1 golf resort location. It's time for a new sign. So this is an example of something that's just, it's obsolete. It's served its time. It's time to get something new. There's the fourth category of protection, a project that protects the underlying valuable asset. And a good example is typically we show or talk about painting, where you see this gentleman painting the wood siding. Painting is necessary to protect the underlying valuable, expensive wood siding so you don't end up replacing the wood siding prematurely. And this is an example of an association that failed to protect their asphalt asset in not doing a seal coat of the asphalt. And obviously, when you fail to protect it, it deteriorates. And instead of an inexpensive seal coat project, this association is faced with a total premature remove and replace project. So that's what we mean when talking about an asset that has to do with protection. And the final is an asset that has catastrophic consequences. Classic example is a water heater that serves an entire building. If this thing fails, I shouldn't say if it fails, but when it fails, it's probably at the least opportune time, and everyone in the building gets no hot water. Cold showers the next morning, and unfortunately something like this tends to happen on a Friday night of a holiday weekend. This is a project that you want to do prematurely on schedule. You don't want to wait until it fails. It's just too unfortunate.
In fact, an association where this happened, where it failed, and people who had to get up early in the morning, they had ice-cold showers, and they threatened to sue the association because of the cold water showers. So we get lots of threats along those lines. Of course, fortunately, nobody followed through, but that's the kind of thing that you don't want to be involved in, is to have these failures unexpectedly.
Right. Thanks, Adrian. The point is that there are different ways components fail, and there's some that are okay, safe to wait on, and there's some that you should really jump on doing. But let me get over to you, Adrian. Let's talk about how the association makes those decisions. Can you touch on the subject of responsibility to make decisions about replacing?
Well, there are a couple of factors that come into play in my experience with boards of directors and their documents. And the first is looking at the documents themselves. And you have typical language in CC&Rs that state that they have to maintain the common areas in a good state of repair. This is common kind of language. It's flexible. And it makes sense. Occasionally, I will run into an older set of documents that will have problematic language. And in the next slide, you'll see where it calls for first that the association maintain the common areas in a first-class condition. This turned out to be central in another lawsuit that I served as an expert in, because the question was for the court, what does that mean, first-class condition? Well, plaintiffs were arguing that it meant near new condition. And then that means, okay, that a roof that has a 20-year lifespan, does that mean you have to replace it every 5 years, every 7 years in order to keep it near new condition? Or that painting that may need to be done every 7 to 10 years, exterior painting needs to be done every 3 to 5 years. And so you have to look at your documents to see what they say, and it may be, as I recommended here to this association, immediately amend their documents and remove that, because it's just a source for litigation. You have an owner who disagrees and they want to sue the association every time on their decision-making process. So you need to look at the documents. The second thing that I see that factors in is whether the components are visible or hidden. If the components are visible, such as pool furniture, that's a typical thing that it would be reserved for. If they have a lot of pool furniture, patio furniture. If the webbing starts to fail, then you replace the webbing. And for most associations, that's typically what they'll do. On our luxury clients, our luxury high-rise associations, when it gets to this point, they don't want to just replace the webbing. They want to replace all of the furniture. They want to keep everything looking near new, so doing the first-class condition, because it's all visible. And then you have the hidden components, and they tend to view those differently. And everybody tends to look at hidden components, such as the pipes in the walls, your drain lines, your water lines. Nobody sees them, and so there's no great cry by the owners, the pipes looking a little worn, can we replace them? Instead, what they do is they wait until they've run their useful life. And as they near the end of their life, then you should have the money set aside in your reserves that you can go through and start replacing the lines. So those are some of the factors that I see involved when in dealing with replacement policies by boards of directors in the associations that we work with.
Well, Adrian, can I get you to speak a little bit further about, like pipes in the wall, which components should appear in the reserve study? Which ones should the board care about making sure that they're in the reserve study?
Well, the things that go into reserve study are going to be the things for which the association is responsible for maintenance. And you notice I didn't say that the association owns, because the ownership of a component does not always dictate who is required to maintain it. That's one of the interesting things about common interest developments. Homeowners associations' maintenance requirements are dictated by the governing documents and sometimes by statute. And typically you have owners are responsible for their separate interests. So if you own a house and a lot, you're responsible for your house. If you own a condominium, you're responsible for your condominium. And then you have the common areas. And here you've got a slide showing a door and a fence. It's going to depend on the common areas. For example, that door may be part of the common areas. And is the association responsible for maintaining that? And a lot of documents will say yes. Other documents will refer to this as a subset of the common areas called exclusive use common areas. And exclusive use common areas may be assigned to the owner to maintain rather than the association. So going back to the pipes in the walls, if those pipes, oh good, here's another picture of fences. Again, responsibility for those fences are going to be dictated not by ownership but by the governing documents as to who maintains those fences. And the pipes in the walls, if they are servicing exclusively a single unit, that's where the exclusive use term comes from, then the documents may assign that the owner of that unit has to maintain those even though the owner doesn't own them. They're owned in common, they're common area, but they're that subset called exclusive use, which the owner is required to maintain. So it will again depend on what the documents dictate as to what goes into that reserve study as something the association is responsible to maintain. And a lot of times that will require perhaps a legal opinion, an attorney to review the documents, create a maintenance chart or maintenance matrix of responsibilities between the owner and the association. And then all of those components for which the association is responsible, those would then would appear in the reserve study.
Adrian, can I take that one step further? Let me show the integration of that, because there's also National Reserve Study standards that come into play. These National Reserve Study standards have been in place since 1998, and they guide what we do in our field. They're kind of like our governing documents. And on the subject of which components appear in the reserve study, we have this set of standards that guide us as far as what's appropriate to appear in a reserve study. So it starts off, as you indicated, with a requirement that the asset be a common area maintenance responsibility. Again, it talks nothing about ownership. Second part of the test is it needs to have a limited life, and the component's progression through its life must be predictable. And finally, the cost needs to be above a minimum threshold of significance to the association. Basically, you don't want to be budgeting for things in reserves that should be handled out of the association's ongoing operational maintenance budget. And as we're talking about laws, let's segue to the issue of state laws. There's now 30 states that have some form of reserve fund, reserve funding, or reserve fund disclosure requirements. And it's at this point in time that I want to turn it back over to you. Adrian, you've specialized in the laws here in California. Do you mind if I take people out for a moment and show you your Davis Sterling website? It's a real powerful resource.
No, please do. The California, as you know, has extensive laws. It's called the Davis Sterling Act that affect all homeowner associations in the state. And that body of law is on our website. We created a website called davissterling.com. Here you see a picture of it on the screen, and we put in that all of the laws affecting associations in the state of California, and then included a lot of commentary as well that goes with it. So as you can see on the main index on the left, you can pick virtually any subject, and it will take you to something about that subject, Adrian, so that people can read up.
I'll show everyone my favorite spot. It's under R. You can scroll down to...
you click on the R, it'll take you down to the
reserves,
R's, where the reserves are.
And then you can get to reserves. You can see a lot of things here, including National Reserve Study.
A sub-menu.
Yeah, including National Reserve Study standards. So there's lots of good things here. And one thing I want to point out is Adrian has a very useful, informative weekly newsletter. And if you go to the newsletters page, you can sign in right here, and for those of you who don't get it, I'd recommend it highly. It's just a great free source of information that'll help you save time and avoid running into problems here and there at your association. So let me get back to our webinar.
Okay, on the states, okay, I know that California, we have in our state all, our own requirements, but you were referencing the national standards. How does that impact or play into what state requirements are?
Good point. We have these two standards going on. We have state laws in at least 30 states now, but we have these national standards. What happens with that? Well, fortunately, one of the primary benefits of National Reserve Study standards, in addition to establishing a credential for professionals who's in this field like myself who serve associations with reserve studies, is these national standards give us common terminology, things like percent funded. Basically, we see no conflict across the country between state laws and National Reserve Study standards. In fact, it's those underlying National Reserve Study standards that allow the state laws to be drafted so that when a state talks about percent funded or how frequent an update with site visit needs to be done, everyone knows exactly what they're talking about. So that's how those two fit together. But Adrian, I want to get back to you. Almost all states are silent on the subject of who should be doing the reserve studies. So can you address that for a moment?
Well, I can tell you who should not be doing the studies, and that's the boards of directors. I advise all of my associations that the boards not try to save a few dollars by doing their own reserve studies. It just creates too much potential liability for them to do that. First of all, they don't have the expertise to be evaluating the condition of the components, what components should be in the reserve study, the remaining life and the cost associated with replacing those. They're volunteers. That's not something that they should be doing. And if they do that without that expertise, then they face potential liability. It's like going into a store. If you break it, you own it. If in this case you do the study, you own the study. And if they're doing this and they miss components, and as a result their large special assessments are being levied against the homeowners, you can almost guarantee there's going to be a lawsuit filed against the board of directors for doing something outside of their expertise. And then the third thing I talk to them about is that they set themselves up for attack by fellow homeowners, by their neighbors, because there's always somebody in the association that is either dislikes the board or they have some kind of personal agenda, and it gives them an avenue for attacking the board. And what they'll do is they'll go to the membership and they'll tell the membership that the study is incompetent, that it was done negligently, that there are errors in the study, that the board is either over-reserving or under-reserving, and frankly, some of that may be true. But even if none of it is true, they can still attack making those claims. And there's no reason for boards to put themselves in that position. So I just advise them, just let somebody else come in, have them do it. You avoid the potential liability, and you avoid the attacks that may come from your neighbors for having done the study yourselves. So that's my position. Now, having said that, in all the years I've been involved in associations, there was one association that had an architect on the board, and this architect actually went through and put together their own study. I advised against it, told them, okay, you can do it. They had the expertise. So they eliminated one of those three elements, and that was the expertise. The architect actually knew what he was doing. But still, when you do the study, the board now owns that study and takes on that potential liability if there are errors and become the target of lawsuits. So in general, it's a bad idea for boards to be doing these studies. They need to turn it over and have somebody with expertise who's credentialed to prepare these studies.
Well, Adrian, let me take that a step further. I think you've made some real strong points there. I want to clarify that there's three types of reserve studies. There's the full reserve study, an update with site visit reserve study, and an update no site visit reserve study. I would agree that it's critical that an association have a very solid full reserve study prepared for their association. There's a different level of significance for that update no site visit reserve study, the kind of update you do on the in-between years, perhaps in between the years that you would do a with site visit update. That's a much simpler process than laying the foundation, which is a much bigger project. So, but it all boils down to credibility. You're trying to get some good information into the hands of the board so they can make smart decisions and communicate what's going on at the association accurately to the owners there. So the bottom line is you want to use the right kind of skills to accomplish what you're trying to do. If it's a no site visit update, then the skill level quite easily can go down. If it's a with site visit update or a full reserve study, then that's the task that you might want to put into the hands of a more diligent professional. But let me move on and say, well, let's say you've got someone preparing the reserve study in-house, but what if it's the management company? Does that add another level of complexity?
Well, for management companies, I mean, there's no legal prohibition, at least in California. There's nothing by statute that says a management company can't do it. And so if they have the expertise, certainly they can sit down and they can prepare a reserve study. But it's problematic, and I discourage my clients from having the management company prepare it because first of all, management companies typically, they're agents of the association. They're used to working in the agent role and working closely with boards of directors, which means they take direction from the board. The board wants them to do something. They, as the agent, they go carry out the directives of the board. So when it comes to doing a reserve study, you lose that independence, and what happens is they tend to slip into that role where they are acting at the direction of the board. They're preparing that reserve study with the input from the board of directors, and you get back to the same problem in that now it's really something that's owned by the board of directors rather than having an independent study. The second problem that sometimes emerges is that if this is a big client for the management company, there's a potential conflict of interest here in that if this is an important client and their study results are going to result in a large special assessment or big increase in dues in order to get them up to a certain level of funding, there may be a backlash from the membership. And if they're afraid of losing the client as a result of that, they may be inclined to skew the results. I'm not saying that all management companies do this. In fact, I don't know that there are very many management companies that actually get involved in reserve studies. But it's one of the potential problems that you face if they are the ones preparing the study. And then perhaps the biggest problem is that most management contracts have a hold harmless and indemnity provision in the contract, which means that if the management company is sued, the association holds them harmless and protects them in the litigation. They defend them, which means that if they prepare a study, they prepare it improperly, there is some large special assessment that results from the study's failures, and a lawsuit gets filed against the management company, association is going to be defending the management company. It is far better to have an independent third party who's a professional. This is what they do. They've got their own insurance, and it insulates the board of directors from that potential liability. So I kind of steer my clients away from having either the board doing it or having the management company do it, and instead have just an independent third party prepare them.
Thanks. The biggest issue I see is the issue of confusion. We don't, the problems that we see are even with the no site visit updates or the with site visit updates, when a management company, a well-intended management company or board of directors starts doing it their own way. We recently updated a reserve study where the prior reserve study was done by the management company, and they had created their own definition for percent funded. And so that's tremendously confusing to the association. So we're trying to do what we can, and with the National Reserve Study Standards, to avoid confusing the association boards and members out there, and that's what we're trying to do with industry professionalism across the board. But
yeah, let me interject. You know, you're talking about the updates. I don't have a problem with the board or the management company involved in the updates, as long as the original underlying study was done by an independent specialist that prepares these kinds of studies, that actually goes out, looks at the property, views the components, takes pictures of them, creates the study. Then doing the updates in between those studies is not a problem. There's just simply providing the factual input that maybe the water heater failed a year early or got replaced a year earlier than was in the schedule. You know, those kinds of updates, those are not a problem. And I think that's what you were referring to earlier when you're talking about the different kinds of studies.
Absolutely. Well, let me get the audience back in the picture here and ask how many of you are in a situation where your management company is involved in the preparation of your reserve studies?
The reserve study or the reserve study updates?
Reserve study updates.
Okay.
And we'll see what's going on out there.
Okay, so it looks like just a small percentage. All right.
Okay, good.
So
Okay.
they must be then, I suspect what's going on here is that they're probably dealing with the original company and just providing them with the information that goes into the updates. And in fact, you do a lot of that yourself, your company?
Absolutely, and that segues nicely to the next point, is that we clearly want the involvement of the board and management in the preparation of the reserve study, because they're the ones who give us the insights as to what has been happening. It's very valuable to get that kind of input and that kind of involvement. So if the board's not preparing the reserve study, or if management is not preparing the reserve study and hiring an outside professional like our company, it's great to get those insights, and that's very valuable. Well, let me get on to the next subject and ask the question, well, whose reserve study is it? Now that it's prepared, is it the board's document that they get to dictate what it looks like, or is it the reserve study preparer's document?
Well, it's whoever prepares the document, they own the document, and it's like a legal opinion. When a board comes to me and says we need a legal opinion involving maintenance responsibilities involving some particular issue, or whatever the opinion might involve, I will look at the facts, I'm going to look at the law, look at their documents, and I'll prepare an opinion. If they were to come to me and say, Adrian, we want you to prepare an opinion that says the following, here's what we want you to write, I'm not going to do that. They don't own that opinion. They don't get to write the opinion. I'm the one that writes the opinion. So the same thing would apply to the reserve studies. If you're going to hire a reserve specialist to prepare the study, then it's the reserve specialist's responsibility to prepare that study, and it's their input that goes into it. And if the board tampers with it, again, they own it, and they're going to be, now they take on that potential liability for having tampered with the document. They need to just allow it to come in, and it's going to be whatever it's going to be. So if you prepare it, you look at the numbers, you look at the amount funded, and they have a deficiency, then that's what you provide to the board of directors. Now, the board, there's kind of a second component here. So there's the study, which you prepare and present to them, and then there's the funding element. In California, there's a disclosure requirement that goes out to the membership. Not only a disclosure of what the components are, what the remaining life is, but how the board plans to fund the repair and replacement of those components. And it might be that the board is going to replace everything entirely through special assessments. They're not going to put any money aside for into reserves. They're going to do everything by special assessments. Believe it or not, I actually had a small association in Malibu that's exactly what they did. They were wealthy, and when I argued with them that that's not a good idea, they said, look, it's our money, and we would rather earn a higher rate of return keeping the money and investing it ourselves. And then when a component such as a roof needs to be replaced, the association just tells us, we get out our checkbook and we write a check. Well, most associations can't do that. Members cannot, they don't have money just lying around that they can pull out their checkbook and write out large checks for replacing common area components. And frankly, in this current economic climate, I'm not even sure that Association of Malibu could do that today. The better approach is to have a funding plan that allows small amounts of money to be set aside every year for each component, so that when that component reaches the end of its life, the money is there so that it can be replaced. And then the association then distributes those documents. So the first document you prepare, which is the study of all the components, the funding plan and the disclosure, I suspect you have a hand in and you assist with, but that's basically the board having their input and disclose to the membership how they're going to pay for this.
Right.
What's been your experience on that?
We see it the same way. The reserve study has our logo on the cover, so it's our information inside. Fundamentally, it's the way the board communicates their decisions, their view of the world, is the budget that they prepare that actually puts their money where their mouth is. They're able to say what they want to do. We often might be asked to create a sample case or a what-if analysis, and when we do that as a separate document. We make it look very different because we don't want to communicate we don't want to confuse anyone that that is our true opinion, but we do give our clients the information the way they want to see it, but not in the form of a reserve study. Just we might show them what happens if. But fundamentally, the reserve study should show the truth, whether it's prepared professionally or in-house. National Reserve Study standards dictate that the reserve study is supposed to reflect the realistic physical and financial status of the association. No wishful thinking in the reserve study. If they want to do wishful thinking, they can do that in their own budget or in their own ways to fund the reserves in the future. Adrian, I'm looking at the clock here. We advertised a 45-minute webinar. You and I budgeted some time at the end for questions, but I think we've got still some foundational things here. So if people want to leave, we understand that, but if they can stay, we have a little bit more information that we'd like to go on through. Are you okay with that, Adrian?
Sure, sounds good to me.
Okay, next topic that we want to talk about is what happens when the board disagrees with findings in the reserve study for good reason, because there's something patently wrong in the document. Adrian? Oh,
okay, well, if there's something that is wrong in the document, obviously I think the board of directors should communicate that to you as the preparer, and then you take it from there. Now, what happens when you receive that kind of information? What do you do?
Well, first off, we hope it's not human error. We hope it's a miscommunication, or, well, we try to do our best, and fortunately more and more reserve studies are updates, and so we're building on the foundation of accurate information that was prepared before. So the bottom line is the reserve study should accurately reflect the physical and financial situation at the association. If it's not accurate, it should be revised. But then let me flip that question. What about if the reserve study is accurately prepared and the board doesn't take the advice? What happens then?
Well, this is an attorney's favorite expression, and that is, it depends. It's going to depend on the reason why. If the association is in the middle of a large roof replacement project. They've got tenting, termite tenting of the buildings, and they're also scheduled at the same time to be painting those rusty iron rails that you showed earlier in one of those slides. Well, that's something that they can put off. The rails can be put off for a year, and once all the other major work is done, they can go back and they sand off the rust and they repaint those. That's not a safety issue, so that really is inconsequential. If there is a safety issue involved or something real significant that, for example, that boiler you showed earlier, that big water heater up on the roof that supplied hot water for everybody in the building, and let's say that it's 20 years old, it's at the end of its useful life, it's been scheduled for replacement, and the board decides that they want to save a few bucks and not do it this year, but wait a couple of years. And it doesn't seem to be leaking, nothing's going on. Now, having deviated from the study, they take on potential liability. What if 6 months later that thing fails catastrophically? And I don't mean that it just stops producing hot water, that it actually bursts for some reason. It floods through the roof into the units down below, and there's a lot of property damage. Okay, you're going to have some very unhappy people that not only don't have hot water, but they're going to have a lot of water damage. And so it leads to then potential litigation involving that. And what will happen then is that the reserve study, instead of becoming a guideline for the board to use, now becomes evidence in court that here's what they were supposed to do and they didn't do it, and the board better have a good explanation as to why they didn't do it. So can a board deviate from a study? Yes, they can, but they better have a good reason for why they're deviating. And if it's like the iron railing not getting paid in 1 year, that's not a big deal. If it's a major component or roofing system, other kinds of systems that can result in significant damage, then they need to be sticking to the schedule, planning on and actually making the repairs and replacements as they come up.
Okay.
Now, I see you want to do a poll at this point?
Yeah, let's ask a question. Let's find out how many of our attendees are actually crafting their budget following the recommendation in the reserve study. I'd like to see that. So how many of you are setting your budget according to what's recommended in the reserve study? Let's see what actually is happening out there in the real world.
Okay, interesting results. All right, well, the first two, the yes exactly and the yes pretty close, I think they're in good shape. It's the no ones that are going to have a problem. If they're not following fairly closely their study recommendations, and there are failures, there are large special assessments or other kinds of problems that result, they're going to have a lot of unhappy homeowners and potential lawsuits. So this is just something that they need to be taking another look at with their boards and looking at the numbers and maybe coming up with a better plan for dealing with the reserve items. One of the things that is fairly true probably across all 50 states, under the Corporations Code, there's a provision called the Business Judgment Rule. I think we've got a slide for that if you could pull that up. And the Business Judgment Rule states that the courts will defer the boards, and boards will not have any personal liability if the decisions that they make are in good faith. And then the second one, if it's done in a manner the director believes to be in the best interest of the corporation. And then the third one is with such care, including reasonable inquiry, as an ordinarily prudent person in a like position would do under similar circumstances. So it's the third one that gets the boards in trouble. The first two, boards are usually acting in good faith. If they're going to delay replacement of a major component, a roof or a boiler, it's usually because they want to save some money for the association, and so that they're doing this in good faith and in a manner they believe to be in the best interest of the corporation. What the jury is going to be looking at when it comes to litigation is that did they make reasonable inquiry? Did they talk to somebody, the reserve specialist, another roofing specialist, and take a good hard look at the roof? And would an ordinarily prudent person have made a similar decision? And those are the kinds of things that the courts will be looking at if there's a deviation, a significant deviation from the reserve study that results in damage, injury to persons and or property as a result of that deviation. So something that boards really need to be careful about and talk to their attorneys and talk to their reserve specialists when they're looking at the reserves or deviating from the reserves.
Well, Adrian, let me ask, since a reserve study is a time-dependent document and advice given in 2005 doesn't really give good advice here in 2012, how often should a reserve study update be done?
Well, I know that some states will have their own schedules. There may be some that say every 5 years. California does it every 3 years, and that's actually a pretty good cycle for doing the major study and then the updates in between. So what it does is it gives you pretty current numbers, good numbers to work with, because you have to make those disclosures to the membership, and they're going to be as part of their planning process, and because you don't want any unexpected, any surprises, any big special assessments. So if you stay pretty current with it, have a good cycle, 3-year cycle on the major study and then updates, I think you're in pretty good shape.
Okay. Let me take a moment and get us out of the presentation here and get to our website and just take a moment to show how we try to make that easy for an association. This is reservestudy.com, and you can see here we have a simple icon you can click on, request a proposal. That's how you can get a proposal to update your reserve study or get a foundational full reserve study. And right below it is an icon you can click to join our email list if you want to be a part of getting news, upcoming webinars, or the ongoing Learning Center activities that we have going on at Association Reserves. You've got a library of information, obviously our webinars, the ones we have scheduled, the ones we have recorded, and a library of documents. A lot of good resources that we have, all available for the associations. And again, part of our desire to help associations have success and to get the information they need, and obviously the reserve study updates that they need. Let me get us back to the presentation here. And let me ask Adrian, next question is, with that reserve study document, is the board responsible to distribute the entire reserve study, which may be a 20 to 50 to 100 pages, or just a portion of the reserve study?
Well, if the state law doesn't require distribution of the entire study, a summary is more than sufficient. As long as you keep the original, the full study on file in the association's office, and that members are free to come by, look at it, copy it. You want to make it freely available to them and not necessarily have to go through the costly expense of personally distributing it to them. The other thing is you may want to post it on the website, the full study, so that it's available for them to look at and download in a password-protected portion of the site. Because the owners, in turn, have to make disclosures when it comes to either refinancing or sales. And the lenders are becoming much more sophisticated in the sales process, and they're realizing that reserves, what an association has in the reserves, if anything at all, can significantly impact the buyer of a unit. And if they're going to loan money to someone to buy the unit, they don't want that buyer 6 months later to get hit with a $20,000 special assessment and walk away from the unit because they can't pay it. So the lenders want to know that the associations have healthy reserves, and those reserve studies are essential to helping the boards plan for and set aside monies into those reserves. So let me go back for a second. Does the board have to disclose? I think they have to disclose to the members. Members have a right to know. Do they have to disclose to a buyer? Well, the association is not a party to the transaction. The association is neither a buyer nor a seller. So they have no obligation to the buyer unless that obligation has been set by law. And increasingly statutes, and for example here in California, are now requiring that the associations provide these things into escrow. And even if the state doesn't have the requirement, they need to provide it to the owner of the unit so that he in turn can provide it to the buyer. So if the association wants to stay out of litigation, disclose, disclose, disclose. They need to make this stuff available and not be shy about it.
Okay, Adrian, last question of the day. Any comments about, as we talk about unit sales, any comments about FHA compliance?
Oh yes, becoming a major player now. The FHA didn't used to be. The FHA insures loans. What they do is, for low-income, people, instead of having to put 20% down, the FHA will say to a bank, we'll insure buyers if they put down 3, 4, 5%, and to make sure that you don't, get stuck with a bad loan. Well, the FHA 5 years ago had maybe 3% of the entire market. Today they have 30 to 40% of the entire market, and they're significant in that they now will insure loans up to $730,000. The FHA has also recognized the value of reserves, and they're not willing to insure buyers into developments where there are no reserves or some kind of plan or reserve contribution. Now the FHA hasn't said, and what they did was in 2009, as a result of the whole housing market collapse and the whole crisis in the housing industry, they started issuing letters which set standards. One of the standards that they set was that associations had to be contributing money into the reserves equivalent to 10% of their budget. And I'm sure you've read and looked at that yourself because this impacts your industry. What's your take on what's going on with the FHA?
Same thing that you just mentioned. The requirement, the reserve requirement on FHA compliance for an association means that an association needs to be setting aside at least 10% of its budget towards reserves. That shouldn't be a problem. It shouldn't be a threshold too hard for an association to meet, because we find that most associations will need to be setting aside 15 to 40% of their budget towards reserves to keep up with ongoing deterioration. So the 10% FHA requirement should not be a hard requirement to meet. It's a lot like it does not measure the strength or adequacy of the reserve fund. It only demonstrates a good habit. Just like wearing your seatbelt doesn't make you a safe driver, it just demonstrates that you have a good habit. So that 10%, all it does is just demonstrate that the board is in the good habit of setting a minimum amount of reserves aside. Well, Adrian, looking at the time, we are there. Both our companies, Association Reserves and Adams Kessler, are in business to support the needs of community associations. We're investing our time in webinars like this to try to help associations have success. If you do have a need for an updated reserve study proposal, please visit reservestudy.com and request a proposal. And I'm sure on behalf of Adrian that if you're a California association in need of some wise legal counsel, please go to the Davis Sterling website or the Adams Kessler Law Firm website.
Thank you, Robert. I appreciate that.
And again, speaking for the both of us, it's a pleasure to spend this time with, well, Adrian, it's a pleasure to spend some time with you in preparation for this and doing this session. And that concludes our session today. Chris, can I turn the floor over to you as you do the wrap-up, please?
Great. Thank you, Robert and Adrian. That does conclude our webinar. If anyone is interested in the recorded version of this or any other webinar, you can search for them on YouTube or link to them via the speaker's websites. If you'd like to receive the speaker's newsletters or receive announcements of future webinars, please visit their websites to sign up. As you exit this webinar, a survey will display. If you could help us out by completing the survey, we'll be happy to email you an outline of the webinar. I want to thank you all for attending. If you have any questions or if there's any way we can be of service to you, please don't hesitate to contact us. Thank you again. Goodbye.